Hello and welcome to the Law Lab. Here, we dissect and unpack everything legal. My name continues to be Jacqueline Fua Opoku. Today, we'll be bringing our topic, terms of a contract, to an end. We have gone through the definition of terms of a contract, we have classified the terms of a contract, and we have delved into ascertainment of terms of a contract. Today, we'll be dealing with exclusion clauses or limitation clauses in relation to terms of a contract. Exclusion simply means that not forming part of something, or you are not being added to something or an action. Hence, exclusion clauses are incorporated into terms of a contract in order to limit the liability or to remove the liability that a party is entitled to under a contract. For instance, when a contract is entered into by Ama and Akusia, and Ama, who is the offeror, states that although I am offering this contract to you and you are accepting this contract, I do not intend to be bound by this particular term of a contract. Or even if I'm being bound, the liability I'm supposed to undergo or the responsibility I'm supposed to have under this particular contract is going to be reduced or is not going to be part of the contract at all. When under common law, when there is an exclusion clause, the law is that you must bring it to the notice of the other party, meaning the party who intends to rely on the exclusion clause or the limitation clause must take reasonable steps or the necessary steps in order to bring it to the attention of the other party, or else he or she cannot rely on that exclusion clause. I will state it again. The rule for exclusion clause is that for one to rely on the exclusion clause incorporated in the contract, the party seeking to rely on that exclusion clause must take the necessary steps and bring it to the notice of the other party. That means that if you do not take the necessary steps to bring it to the notice of the other party, then the court will not allow you to rely on that exclusion clause. Therefore, the exclusion clause will be in the contract, but you cannot rely on it or it will not be enforceable for you. And also, under common law, when a party seeks to rely on an exclusion clause, he or she must ensure that the exclusion clause is incorporated into the terms of the contract or into the contract. For instance, there is a contract between A and B, and A states in the contract that even if I do not deliver the goods to you on time, you cannot recover your money or you can only recover part of the money. If A intends to rely on this exclusion clause, A must ensure that the exclusion clause is part or is incorporated. When we state that something is incorporated, that means at the time of the contract, it was part of the contract and not when the dispute arises that he or she is going to state that there was an exclusion clause of which I intend to rely on. Hence, if you want to rely on an exclusion clause, the first thing is that you must bring it to the attention of the other party. And the second rule is that you must ensure that at the time or before entering into the contract, the exclusion clause was incorporated into the contract, making it form part of the necessary terms of the contract. In the case of Parker versus Southeastern Railway, this is a case between a plaintiff and a defendant, and then the plaintiff was a passenger on the train that was moving from one city to the other. He boarded the train and decided to leave his bag in the cloakroom. A cloakroom is where you keep your luggages or your bags in when you are on the train. So the plaintiff, Mr. Parker, decided to keep his bag in the cloakroom, and when you keep your bag there, you are given a ticket. And Mr. Parker was given this ticket, but the only things that were in front of the ticket were the ticket number and the date for which he purchased the ticket. And then there was a clause that was stated at the front page of the ticket, which was see the back of the ticket. Unknown to Mr. Parker, there was an exclusion clause which was behind the ticket, stating that the train company will not be held liable for any bag or any luggage that exceeds the cost of 10 euros. Because Mr. Parker deemed it unnecessary to see the back of the ticket, he did not read it, and when he got to his destination, his bag was nowhere to be found, and his bag cost 24.10 euros. He then sued the defendant for the recovery of his bag. The defendant argued that he was only liable to pay 10 euros of the bag which Mr. Parker seeks to recover from them, because there was an exclusion clause stating that the train company is only liable for 10 euros of any luggage that will be missing. The court stated that at the time the contract was entered into between Mr. Parker and then the train company, the exclusion clause was not brought to the attention of Mr. Parker, and that since the exclusion clause was not brought to the attention of Mr. Parker, the defendant company could not rely on it. The court stated that for a person to rely on an exclusion clause which is part of the contract, the person who seeks to rely on this clause must take reasonable steps and bring it to the attention of the other party, meaning the clause that was stated that see back, any other person wouldn't have looked at what was behind the ticket, because all that they needed to know was the cost of the ticket and the date for which the contract was entered into between the parties. Hence, Mr. Parker was able to recover the amount of the remedy he was seeking for. Another case to consider is the case of Chapelton versus Barry UDC. In Chapelton versus Barry UDC, this was when the plaintiff went to the beach and he decided to hire a chair to sit on at the beach. When he went, the place where the chairs were parked, the only notice that was there was that the price of the chair to be hired, and that when they are done, they are supposed to return the chair back to where it was. The plaintiff took the chair, and when he was going, they told him that he's supposed to pay for the chair, and he paid for it. He was given a ticket number. There was nothing indicating that there was going to be an exclusion clause on the ticket that was given to the plaintiff. Later on, the plaintiff sat on this chair and fell, and then he was injured, and he sued to recover damages for the injury he suffered. The defendant company argued that the ticket they gave him had an exclusion clause which stated that the company would not be held liable for any accident or injury caused by the chair. But the court in its ruling or in its decision stated that the defendant company could not rely on this exclusion clause because at the time the contract was entered into, the exclusion clause was not incorporated because the contract was formed at the time he took the chair from where it was parked, and the only notice that was at the place where the chairs were parked was that when you are done using the chair, you are supposed to return it. Hence, the defendant company could not rely on this exclusion clause which was on the ticket number. Another reason the court gave was that the ticket given to the plaintiff was deemed to be a receipt for the payment he had made, and there was no reason the plaintiff was going to think that the ticket number was going to have an exclusion clause in it. So the case of Chapelton versus Barry UDC confirms that if a party seeks to rely on an exclusion clause, he must ensure that that said exclusion clause is incorporated into the contract either at the time of the contract or before the contract. If this is not done, a party cannot rely on an exclusion clause. So far, today, we have discussed what an exclusion clause is, the general rule to exclusion clauses, and the exceptions, and also cases to back what an exclusion clause is. In our journey on terms of a contract, we have come to know what terms of a contract is. We have also known what classification of terms of a contract is. That classification includes condition, warranty, and innominate terms. We've also come so far to look at ascertainment of terms of a contract, of which I stated that is to know whether or not a particular statement made will form part of the contract. And we finalized our discussion on ascertainment of the terms of a contract by concluding on exclusion clauses, and that exclusion clauses deemed to limit the liability a person is supposed to have under terms of a contract or under a contract. Thank you for joining us in our journey on terms of a contract. Continue to like and subscribe and share on all other platforms. My name remains Jacqueline Opoku. Thank you.